Good afternoon, ladies and gentlemen, and welcome to the North Sydney Local Planning Panel. I'd like to advise you that we have two items that are part of a public meeting that we'll start with, and then we have four items which are not part of a public meeting, which we'll deal with in camera. If you have one of the latter items, we'll introduce you to the panel as those items become available. Before introducing you to each of the panel, can I acknowledge, please, the past and present traditional owners of this land, which we are all located on and indeed considering this afternoon. Can I also introduce you to each of the panel members who will be deliberating on the 6 items that are part of our agenda. I'll start, if I may. My name is Gary Shields. I'm your chairman for today. My background is in consulting and as a local government planner. I have a PhD in planning and I have a master's degree in planning, urban design and traffic. I do not have any conflicts with any of the items on the agenda this afternoon, and everyone has signed forms to that effect. Can I also say, before introducing the next panelists, that we've each individually inspected the sites and we've had the benefit of being provided with the objections that have been submitted to the council. So please don't feel as though you have to read every particular item in your submission, because we certainly have considered those items. Jan McCready, can I ask you to unmute and introduce yourself to the wider area? Thank you.
Yes, it's Jan Morell, but the other one's a very good friend of mine, so that's okay.
Oh, sorry. Freudian slip there.
Pardon. So Jan Morell, and I've been a planner for some 40 years. My last full-time position was a commissioner with the Land and Environment Court for 14 years, and since that time I've been chairing and an independent consultant on both state and local government panels. Thank you. And I
Thanks, Jan. And apologies for the faux pas. Linda.
Yes, Linda McClure. I've got 40 years experience largely in state and local government planning, more recently as a consultant to local government. My most recent local government employment was at Willoughby City Council for 20 years as strategic planning manager. So I've done a lot of work with North Sydney over the years and I'm aware of their issues. Thank you.
Thank you. And you have no conflicts today?
No conflicts of interest.
Thank you. Virginia.
Hello, everyone. My name is Virginia Waller. I'm a registered architect in New South Wales. I've been a member on the North Sydney Independent Planning Panel since its inception. I'm also in the role of community representative. As Gary has advised, I have no conflicts of interest with any of the items on the agenda this afternoon.
Thank you, Virginia. Ladies and gentlemen, before you each get provided with your opportunity to speak, can I say again that we've had the benefit of being apprised of your concerns. We've also had the benefit of a pre-briefing from the council officers, and we have a series of, may I say, very detailed reports before us that identify the issues that you may or may not be concerned about, but certainly we will consider today. I'll just say again the protocol for today. The first 2 items will be part of a public meeting. The last 4 will be part of a closed meeting. We will make the determinations on the 6 items after the last item's been dealt with and people have presented, and the results of the panel's determination will be provided on the website in the next 48 hours or thereabouts. Can we start then, please, with item 1, which is 13 Shell Cove Road. And I've got I think a Mr. and Mrs. Anthony presenting, is that correct? Who's our first submitter? Sorry, it's Mr.
Applicant.
Sorry, the applicant?
There's Dr. Richard Lamb as well.
You're just breaking up there, I'm sorry.
Excuse me.
Can you hear me? Yeah.
I can now.
Yep.
Are we hearing from the objectors first?
Yep. So we've got Dr. Richard Lamb, if you want him to speak. Or
He's on behalf of the applicant.
Yep. He's on behalf of the applicant.
There are no objectors speaking, only as observers.
They're all observers, are they?
Yes, that's correct.
Yeah.
Right.
And just
Okay.
2 consultants on behalf of the applicant.
And that's Mr. Waghorn and Dr. Lamb, is it?
Correct.
That's correct.
And one other. Thank you. All right. Who would like to go first, Mr. Waghorn or Dr. Lamb?
Dr. Shields, I will take the reins and start if you can hear me loud and clear.
I can hear you loud and clear. Thank you, Mr. Waghorn.
Thank you, Mr. Chair. Mr. Chair, on behalf of the applicant, this represents a returning item to the local planning panel. The first planning panel was held on the 4th of August, where I believe only Jan Morell was the only panel member today that was on that panel, which graciously gave our clients a deferral of the application, which was against the recommendation for refusal from council staff. Before you today is a recommendation for approval, but a deferred commencement approval. Now, whilst our clients are very happy to finally be receiving some form of approval from council, we were quite surprised at the conditions or the subsections contained in the deferred commencement matters. We did provide late correspondence both from Stephen Davies and myself in relation to those conditions and in relation to a potential probity matter with the application of a deferred commencement condition requiring approval from council's manager of development services. Just touching on that matter first, we understand that council has provided an addendum report and that they do say that they are effectively an agent of the panel and that the legislation allows for it. But whilst I'm not a lawyer, I will make the assertion that it does present a perceived conflict of interest. The panel delegation requires local planning panels to determine matters from council staff, councillors and council. Now, it would be quite ridiculous for council to impose a deferred commencement condition on itself, requiring sign-off, for example, from the manager of development services, and we would put councillors in the same bracket as the directive for the local planning panel delegations do. Therefore, we would respectfully request that at the very least, the deferred commencement condition be deleted. And if you are not with us in relation to the deletion of subsections A to G, that you would at least impose those conditions as, let's just say, standard types of conditions, not a deferred commencement condition. Turning to the specific matters in the deferred commencement, we say that subsections A to G go further than what was recommended by the local planning panel on the 4th of August. Whilst we accept that council's independent planner and heritage officer may have a different opinion, we respectfully request that the panel follow their original reasons for deferral and effectively delete all of these requirements, which to us do not serve a planning purpose. They are not very well conceived and in some cases are unworkable. For example, the first condition, subsection A, it asks for the terrace to be deleted and the eastern wall to be relocated to the west to adjoin the games room. This would effectively create a cantilever of the existing building, which would, in our opinion, create an absurd result just to simply conceal the lowest level, which has a very limited visibility in the first place and has the visual appearance of a house on stilts or with subterranean voids. We say that it serves no planning purpose to do that, and it is contrary to what the local planning panel considered originally on the 4th of August. And secondly, the other most important condition for our clients is condition C, relating to the front porch and veranda. This was not a recommendation for the local planning panel at all. We were of the opinion that the original panel accepted that stairs could be placed in this location, given its limited visibility, and the fact that the alternate, as discussed in in condition C, would require the stairs to be located internally, which would remove original historical fabric. And we would say that would be a poorer planning outcome. I won't go into too much detail further, Mr. Chair, because you do have our late correspondence. We do disagree with the deferred commencement condition and all its subsections. We don't see any planning merit in imposing those conditions. Any changes that were made as a result of the deferral are all reflected in the architectural plans and package. And we commend the amended plan to you, subject to the deletion of the deferred commencement condition. I'll now hand over to Richard Lamb. He just wants to quickly discuss the visual aspects of the proposal, including some of these deferred matters.
Thank you, Mr. Waghorn. Dr.
Thanks,
Lamb.
David. Mr. Chairman, thank you for the opportunity to speak here. I don't want to repeat anything about those conditions. I'm not a legal expert, but I've looked at literally thousands of conditions in my life, and these ones mystify me, I have to say. Can't see that they're workable, and I can't actually see how it is that we've come back to an even more ideological position in relation to the visibility of the lower ground level 2, when the panel clearly said that the lower ground is to be treated as a largely subterranean level that is not invisible. And the panel actually said, if I recall it correctly, that they didn't object to the idea of there being 4 levels. It was only to be accessed internally to generally conceal its presentation as a visible level. Now, I've looked at this many, many times, and honestly, I cannot see how we have failed to achieve what was the reason for the deferral that was presented to us by the panel. It is largely subterranean, almost invisible. It generally conceals its presentation by being, in fact, only 0.9 of a metre high. It has a landscape proposal which would literally make it invisible from either the waterway or the far side of the water on the public pathway that's been contended, and I agree, is an important viewing place. And we haven't had the opportunity to prove that by preparing photo montages that this level would in fact be literally invisible, but I'm absolutely certain that if we did have that opportunity, that's what would be shown by accurately prepared photo montages. And I have the necessary photographs that we could use to set those up if that was thought to be necessary. I don't understand it. I don't understand conditions either that look to me like almost constructive refusal, whereby the condition requires the council to give itself agreement to the condition at some later stage. It just doesn't make sense to me. I'll leave that to people more expert like yourself, Chair. And that's really all I have to say.
Thank you, Dr. Lamb and David Waghorn, or Mr. Waghorn. Mr. Waghorn, Dr. Lamb, how would you, if the panel was sympathetic to your arguments, how would you see the panel satisfying itself that these matters have been effectively considered? If I wanted to make a determination today, or are you implicitly asking the panel to defer the matter generally?
Mr. Chair, we believe that the amended plans and documentation provide sufficient detail to enable the panel to make a determination. We're of the opinion that the requirements in the deferred commencement conditions go over and above what would typically be required. And as I said previously in my statement, serve no planning purpose. So we would respectfully commend the panel to recommend approval. We think you have sufficient information to do so, and would ask for the deletion of condition AA1.
All of AA1?
All of AA1, yes.
Okay, thank you. Does the panel have any questions of the applicant's representatives? No questions? Okay. Thank you, Dr. Lamb. Mr. Waghorn?
Sorry, Mr. Chair. I think Jen Morell's on mute.
I was just going to say, the panel has on numerous occasions delegated authority to the either the general manager and or his deputy and the manager of development services, where it has imposed deferred commencement conditions. And so that is not something that is, and these people are professional people and they're not seen to have a conflict of interest. But I just thought I'd put that on the table so that everybody is aware that that is the procedure and the process that we have used at this panel since its institution, some 6 years ago or more. No, 8 years ago. Thank you.
Thank you.
Sorry, Mr. Chair, can I just say, I accept deferred commencement is a satisfactory way to, I suppose, give additional flexibility. And I know it has been implemented numerous times on this panel, but I'm unaware if it's been implemented for, like in this occasion, for a councillor or staff or council. That's the differentiation.
Can I just say, can I just say that a deferred commencement has always been to the manager of development services, the delegation for the approval of plans in accordance with the deferred commencement conditions. And in the event that plans don't come forward that satisfy the deferred commencement conditions, then on occasion they are put back to the panel.
Mr. Waghorn, are you happy with that answer? Probably not happy with it, but at least.
Look, Mr. Chair, as I said, I completely agree with it as a typical scenario, but it may not be a conflict of interest, a deferred commencement condition. I'm not a lawyer, but if there is a perception of one, I would have thought that the panel would take a precautionary approach and potentially to remove any doubt. As I said, even if you're not with us on the deletion of AA1 in its entirety, we would say you could at least impose some or all of the conditions as a standard condition rather than a deferred commencement.
Thank you, Mr. Waghorn. No other questions, panel?
No, Gary.
Okay. Thanks again, Mr. Waghorn. Thanks again, Dr. Lamb. The panel will consider your comments, your submissions, and make a determination after the final matters dealt with today. Thank you.
Thank you, Mr. Chair. Thank you, panel.
Item 2, and before I leap into item 2, can someone help me by advising who is presenting to us this afternoon? So the list and running sheet that I have here are the people that are listening in rather than presenting. Is that correct?
I've got David Rippingill, who's the applicant. We've got no submitters for this one.
Right. Okay. So we've got 10 people that are listening in, but the applicant's the only one that's submitting. Is that correct?
We've just got the applicant. That's it for this one.
Yes.
No one
yes.
else is here.
Okay. Who's representing the?
David Rippingle.
I'm sorry, David.
Rippingle, that's the applicant.
David, are you there?
Yes, I'm here.
David, can you present your arguments to the panel, please?
Yes, absolutely. Thank you for your time. So my name's David Rippingill, Director at Design Collaborative, the town planners assisting the applicant, the Commodore Hotel. The application's for a refurbishment of the premises, basically to replace the ground floor, semi-ground floor basement car park with a gaming room. There's 3 conditions that we've got an issue with that I want to speak to you about. The first is in relation to trading hours. So council's late night trading controls state that they don't apply retrospectively or to derogate from existing consents. Those existing consents permit the trade of the hotel internally and externally between 5 a.m. and midnight, Monday to Sunday, 5 a.m. to 1 a.m. Thursday to Saturday, and 10 a.m. to 10 p.m. Sunday. The proposed trading hours conditions, which will, on my interpretation, as far as I can tell, apply to the entire premises, including the new gaming area, and will apply a trial period from 10 p.m. for all internal areas and require the cessation of the outdoor trade at 8 p.m. And obviously that's pretty much unworkable for our client. The outdoor area is one of the most popular areas of the pub, and the closure of that area at 8 p.m. Would interrupt the dinner trade. And notwithstanding the imposition of a trial period is unwarranted based on council's controls and the existing operation. In terms of applying a trial period to the new ground floor gaming area, I don't think that is warranted either, and I do not think that's required under council's controls. If I just turn over to council's controls, they're said to apply to certain applications. They're said to apply to a change of use of a premises. There is no change of use in this case. As you would all know, car parking associated with a pub is still a pub. New or extended trading hours to existing premises, we're not changing the trading hours. The refurbishment, additions or extensions that will result in an intensification of an existing use, which I'll get back to. And the last point to which they'll apply is a formulation of trading hours following a trial period. Obviously that doesn't apply here because there is no existing trial period. In terms of that third point, the DCP says an intensification of use means an increase in the capacity of the premises to accommodate additional patrons. At present, the premises has no patron capacity. We offered up a proposed capacity of 405 patrons based on the existing approved drawings in accordance with the National Construction Code deemed to satisfy requirements. That was intentional to avoid any perceived intensification of the existing pub because we wanted to avoid the adoption of a trial period on the premises. In terms of resolving any concern about the late night use of the premises and the potential for impact and what would have been cured by a trial period, obviously this is a gaming area and a small sports bar. There's limits on the patron capacity of that area. It's been assessed in an acoustic report. It's a low risk area in my experience. I've been dealing with hospitality and pubs for more than 10 years, doing these kinds of assessments in front of councils and the Land and Environment Court. A more appropriate condition, in my opinion, would be to require acoustic testing during the first 3 months of operation of the premises. That condition hasn't been proposed, but I think that would be a preferable outcome, particularly with the pro-offered limit on the overall patron capacity consistent with the current operation of the hotel. Turning to the second condition that we do have a concern with is a contribution of, from memory, it's about $40,000. In my submission, I go into a bit of detail on why we have an issue with that. It basically assumes that there's going to be an additional 11 employees at the hotel as a result of the work. That's based on increases in GFA. Whilst there is technically an increase in the GFA, one of those relates to the existing outdoor area, which is being partially enclosed with bifolds that can open and close during inclement weather. The Land Environment Court's previously determined that is interpreted to create GFA, so there'll be no additional employees there. And in the ground floor basement, we're basically moving a gaming room that already exists at another part of the pub. So it'll modestly expand an existing sports bar, which might require additional employees, but nowhere near 11. And the rates are applied at $3,000 per an employee. We're not going to get anywhere near $40,000. So I've suggested instead that council apply a 1% contribution based on the cost of works, which it's open to do, which would result in a contribution of $26,000 instead of $40,000. And my last submission is more a clarification regarding condition C2. A part of the condition, it relates to construction management, but part of the condition specifies that any reversing into the loading dock from Blues Point Road is to be approved by Transport for New South Wales. I just want some clarity around that condition, that it doesn't apply to the general operation of the hotel, and it is specifically in relation to construction management. The issue with that is this is an existing loading dock that the hotel relies upon. There's no guarantee that that approval will be provided by Transport New South Wales, and which would, if that's refused, would basically make this consent unworkable. So I would just like that confirmed, that the reversing the loading dock relates only to construction management. And that's our submission, and so I'm happy to answer any questions.
Thank you, Mr. Rippingill. Does the panel have any questions of Mr. Rippingill?
I do, thank you, Chair. Can I just ask you, David, about the plan of there's a proposed plan of management. With no objection to a plan of management? No,
that's why it was offered up.
Yeah, no, I was just confirming, but it's the hours of operation you are questioning. Okay.
Yes, because the council shouldn't be derogating from those existing approvals. If the conditions adopted in its current wording, then this consent will not be taken up. There'll be no trial period imposed on the hotel. So, because it is commercially, it's unworkable.
Okay, thank you.
David, hi, Virginia here. I had a question more about the pragmatics of the refurbishment of the basement area. So I understand there's modification. It's a basement with car park at the moment. It's going to become a gaming area, a sports bar and gaming area. And you've got these voids from the ground level terrace. And there are these voids along the Blues Point wall.
Yep.
So how do you foresee those? Are they just openings? Is there any weather protection?
Yeah, so those voids will be basically louvered walls. So it's been designed to comply with the Smoke Free Environment Act. It's been assessed on that basis that there are voids there and that they are louvers, and will comply with both before and after midnight acoustic criteria.
So would the louvers be in the horizontal plane or the vertical plane? Like, is there a wall line in that basement, in that basement
I expect
area?
they're going to be horizontal. I'd have to go back to the drawing. Sorry, I wasn't prepared for this question, so I didn't have any of the drawings open.
I'm just wondering about the patrons sitting in the gaming area on that basement level and security. I realize there's a wall on the street boundary of Blues Point Road, and there's a planter somehow supported, but then there's this void because the slab of the ground level is set back, and so there's this opening. I'm just looking at the section that was done. I know it's a DA. Anyway, you're saying they're horizontal louvers and they're controlling mechanical airflow. Is that right?
They don't control mechanical airflow. It's just passive airflow. So just in order to comply with the Smoke Free Environment Act, you have to provide 25% access to the outside. So if you take into account all of the wall and ceiling area throughout that space, those voids will provide 25% proportional area to comply with the Smoke Free Environment Act in order to permit smoking.
Okay.
Any other questions? No other questions? Just a quick one, Mr. Rippingill. You agree, would you not, that there's a 200 square metre increase in GFA?
I agree with that.
Okay.
Uh,
I
in
thought
terms-
you said there wasn't.
Well,
There's not an increase in building bulk, but there is an increase in GFA.
yeah, certainly. There's two parts, I guess, to that question. As I said, with the first floor terrace, which is presently excluded from GFA as a result of those bifolds that have been put in, even though they're removable, the fact that the whole area can be made to be protected from the weather, the Land Environment Court's previously decided that was in relation to residential buildings and louvers that creates GFA. In terms of the ground floor, I differ with the council's opinion on whether that's presently existing GFA. My understanding from the case law is that any parking that's provided in addition to what's required by council is to be considered GFA under the current definitions. And because North Sydney Council doesn't require any parking, that area is presently GFA. And I guess there'd be a bit of discussion about the 1.4 metre internal wall height and what that means for that area, which is substantially enclosed as well. So that's, I guess, where the issue is of GFA as it relates to the application of those late night trading controls. The first test is whether it results in an increase of patron capacity, and then there's the sub-test of how that might be verified. But as I've said, we've proposed a patron capacity based on the existing deemed to satisfy National Construction Code. And from memory, that's a limit based on toilets rather than floor area or exit widths. And we've maintained that in this application, notwithstanding the increase in floor area and toilets.
Thank you for that. Panel, any other questions?
No, thank you, Gary.
Thank you all. That concludes our public meeting for today. We now go to an in-camera meeting for the other 4 items. Mr. Rippingill, the panel will make a determination and will consider your submissions. Thank you for those. And in the next 48 hours or so, it should be on Council's website. So thank you for your attendance. Thank you.